Lose.
Senator Stephens.
Thank you, Mr Acting Deputy President. Tonight I rise to speak on the revisionist efforts of this government in their determination to wind back the not-for-profit reform agenda that's been developed in the past decade through the work of the Productivity Commission, the Australian Taxation Office, the Australian Charities and Not-for-Profit Commission, and the range of charities and not-for-profit organisations who've lent their considerable expertise and efforts to improving the governance and transparency of Australia's charitable sector. Minister Andrews has signalled his intentions very clearly, and it was reiterated yesterday by his spokesperson. The government is committed to winding back the ACNC and replacing it with a centre of excellence. In his second reading speech on the introduction of the social security legislation, he introduced an additional amendment. He said the new measure will delay the commencement of the Charities Act 2013 by 9 months from the 1st of January to the 1st of September 2014. The Charities Act 2013 defines charity and charitable purpose for the purposes of all Commonwealth legislation. The significance of this delay is not to be underestimated. Until the passing of the Australian Charities Act in the last parliamentary session, the meaning of charity and charitable purpose had not been previously comprehensively defined for the purpose of Commonwealth law. It had been administered on the basis of principles derived from common law, and the common law meaning had developed over 400 years, largely based on the preamble to the 1601 Statute of Charitable Uses. The development of the definition of charity and charitable purpose through case law since that time has resulted in charity law that is in some cases quite clear and inconsistent, or that does not adequately address matters relevant to Australia's contemporary charity sector. A statutory definition of charity and charitable purpose is important. It was first recommended in the report of the 2001 inquiry into the definition of charities and related organisations, and in later reports including Australia's Future Tax System Review in 2010, the Productivity Commission recommended it in its 2010 report, Contribution of the Not-for-Profit Sector, the introduction of a statutory definition in accordance with the recommendations of the 2001 inquiry. The definition aims to preserve common law principles, with some minor variations. The definition is informed by the 2001 inquiry, which identified the principles underlying the common law. And the definition also takes into account the findings of more recent judicial decisions that further clarify the meaning of charity, including the Aid Watch decision, which extended charity's ability to advance public debate. Importantly, the definition retains the flexibility inherent in the common law that enables the courts, as well as Parliament, to continue to develop the definition within the statutory framework. And that will ensure that the definition remains appropriate and reflects modern society and community needs as they evolve over time. So the bill sets out the key principles for an entity to be a charity, including, of course, that it must be not-for-profit and have only charitable purposes, except for any ancillary or incidental purpose that further aid the charitable purpose. The charitable purposes must be for the public benefit. A purpose that an entity has is for the public benefit if the achievement of the purpose would be of public benefit and the benefit from the purpose is available to members of the general public or a sufficient section of the general public, and the nature of the benefit may be tangible or intangible. So for many of us, that might sound a bit like gobbledygook, but it is really actually very important, Mr Acting Deputy President. The new considerations in the 2013 Charities Law make some very specific provisions. The first is the implications that it has for Indigenous organisations. One departure from common law principles relates to entities with native title or other traditional rights in connection with the land. These entities might fail a public benefit test because they provide benefits only to Indigenous individuals who are related or have some other special relationship with the other potential benefit recipients, are treated as being for the public benefit. And we know that there are actually instances of philanthropic funds not being able to support projects in remote communities because the entities that operate there do not have DGR status. Then there's the whole issue of a presumption of benefit. Consistent with common law, the statutory definition retains presumptions of benefit for certain charitable purposes. They're the relief of poverty, distress and disadvantage of individuals and families, preventing and relieving sickness and disease or human suffering, the care and support of aged and individuals with disability, advancing education and advancing religion. So the bill extends the presumption to the whole of the public benefit test for these purposes. And this is of particular interest, for example, to those following the current case of the anti-wind campaigning organisation, the Warborough Foundation, whose directors include former Coalition Minister Michael Wooldridge and insolvency specialist Tony Hodgkin, which is actually being investigated right now by the ATO and the ACNC as to whether or not it's entitled to its tax-deductible charitable status. The Charities Bill also reflects the AidWatch decision that charities may have a purpose to generate public debate about a charitable purpose. That means allows for advocacy around a charitable purpose, including a sole purpose of promoting or opposing a change of law or government policy relevant to another charitable purpose. And finally, the issue about disaster relief and recovery. Another area of the bill extends common law principles relating to the purpose of assisting rebuilding, repairing or securing assets after a disaster, in furtherance of the proposals of exempt entities within the meaning of the Income Tax Act 1997. So that purpose is included within the charitable purpose, and the effect of that is to extend charitable purposes to include re-establishing not-for-profit community assets after a disaster, independently of the relief of individual distress. And colleagues may actually recall the measures that had to be put in place after the Victorian bushfires so that philanthropic monies and funds raised by the government's bushfire appeal could be provided to local bushfire brigades and local organisations that didn't have DGR status. So it was a timely change supporting rebuilding and reconstruction after a disaster. Let's just hope that we don't witness similar disasters this summer. So there are 4 very clear reasons why the government should not delay the Charities Bill, which is due to come into effect on the 1st of January. The Labor government moved to resolve those uncertainties in the law, and to delay those provisions is to subject organisations to continued uncertainty and the prospect of further legal action. And the only justification given by the Minister was the delay will mean we can work holistically with civil society, consulting a range of stakeholders, including charity law specialists who provide advice to the sector. Well, it was Prime Minister Howard who, in announcing the establishment of the Charity Definition Inquiry in September 2000, said, "We need to ensure that the legislative and administrative framework in which they operate is appropriate to the modern social and economic environment." The last-minute inclusion in the legislation to delay the implementation of the Charities Bill is actually a slap in the face for the significant group of advisors, charity law specialists, academics, accountants and organisers who've worked for more than a decade to come to agreement on the provisions of the Charities Bill that was passed in the last Parliament. There's already been widespread consultation, and the new legislation has attracted almost universal support from charity law experts in the charity sector, and I attended a very significant conference at the Queensland University of Technology on modernising charity law, facilitated by Professor Miles McGregor-Lowndes. That legislation drew from the best of other jurisdictions and guarded against the missteps that had occurred in other countries, leading to legal challenges and precedents. So the new definition of Charities Bill achieves important goals, including ensuring the High Court decision to ensure that charities can advocate changes to laws, modernising current law to recognise charitable purposes as the protection of human rights, the promotion of reconciliation and tolerance, and to acknowledge that modern charities advance their cause by researching, educating, preventing and raising awareness. The question everyone should be asking is this: why does this government not want a modern definition of charity, which is also enshrines the right of charities to advocate in legislation? Last week, Mr Brough, in a parliamentary contribution, suggested that charities and not-for-profit organisations are spending too much on marketing and administration, and he urged the government to link DGR status to greater disclosure. He argued for greater transparency, something which is being achieved through the Charities Register established by the ACNC. He quoted the Choice article of 2008, and he can be forgiven for not knowing how much progress has been made. But the truth of it is that the government has a national register, it has an ACNC, and it should allow this Charity Act to proceed.
Senator Moore.